Participants here. Sorry, good afternoon, everybody. I see we've got just over 70 participants currently attending, so I might just give it another minute or two to allow others to join, because I know we had upwards of just 100 registered for this talk. So we'll just give it 1 minute, please. Okay, I can see the numbers going up. We've hit the 100 mark, or certainly getting close to it. So I think we'll just start now as it's 12:32. So good afternoon, everybody. My name is Graham Crowley, and I'm a director in Deloitte, and I'm also a member of the SAI GI Committee. I'm delighted to welcome you to our first GI CPD event of the year, called Changing Liability Claims Environment: Perspectives from Claims, Legal and Actuarial. I can see that almost 100 participants at this event, which is great and shows that this is a very relevant topic of interest. I suppose we have the standard disclaimer next. So just that the views expressed are those the views expressed in this presentation are those of the presenters and not necessarily those of their employers or of the Society of Actuaries. The webinar is being recorded. Sorry, we've competency wheel, of course. So here we can see the key competencies that are being covered in this talk. So industry issues, of course, judgment and risk management. And then just to remind people that the webinar is being recorded, but the Q&A segment is not being recorded, and we hope to post to ActiveView and YouTube after the event. Participants can submit questions at any point throughout the webinar. The questions can be submitted through the Q&A portal, which should appear at the bottom of everyone's screen, and the questions can be posted alongside your name or anonymously. Just from a CPD perspective, I would like to remind attendees that once you have registered with your full name, we will have record of your attendance. There's no longer a need for verifiable CPD in Society's CPD scheme, but we appreciate that there may be other organisations that require verifiability. And I suppose if we look at the talk overall, I'm going to host a discussion with industry experts from the claims, legal and actuarial professions today and get their perspectives on the ever-evolving claims environment, including impending changes to the personal injuries guidelines. As summarised in our talk description, we're going to have Rosalind Carroll, who's Chief Executive Officer of the Injuries Resolution Board, sometimes called shortened to IRB. We'll also have Dr. Swan, Head of Research and Policy at the IRB. We have Martin Browne, a partner with HF Ireland, and Ronan Mulligan, actuarial partner with Risk Modelling Services at PwC. So we're going to start the meeting with a presentation from the IRB, who will give their perspective on the changing personal injury landscape and latest trends in personal injuries claims. I'll now hand you over to Rosalind, who will bring you through the presentation.
Thanks, Graham. I'm just going to share my presentation. Yeah, hopefully everybody can see that okay. So good afternoon, everybody, and thank you firstly to the Society for inviting the Injuries Resolution Board to speak today. We're delighted to be here. I'm joined by my colleague, who you'll hear from shortly, Dr. Swan, who's our Head of Research. And what we're going to try and do is give you a very brief, I suppose, whistle-stop tour of the changing personal injuries environment, which will hopefully kind of set a backdrop to the discussions that we'll have as a panel thereafter. So what I'm going to try and do is I will speak firstly, I suppose, to kind of what's changed in the environment, and then I suppose specifically how the Injuries Resolution Board has been changing what we do in terms of this space as well. Most of you will have heard that there's new draft personal injury guidelines. So again, just in terms of context, I might just set a slide or two there in terms of the framework for the discussion that we'll have thereafter. And then Lauren is going to go through the latest trends in the personal injuries area based on the data that we have, specifically at where we're at with award values, and then a more detailed focus on motor liability claims in particular and public liability claims based on some recent research reports that we've done in that area. I suppose, and I'm only going to speak briefly, but I just wanted to start very briefly with just kind of a reflection in terms of where we're at in an environment. I think sometimes we're so focused on award values, sometimes we don't step back a little bit to kind of go how much this environment has changed and how quickly it has changed over the last number of years. And obviously COVID had a significant impact in terms of the area. And we can come back to that when we look at some of the volumes in terms of our claims. But more importantly than that, I suppose, after years and years of working groups, the Personal Injury Commission and so on being in place, and where Ireland, I suppose, was always just seen as a complete outlier in terms of how we deal with claims, there being a real sense of you don't know what you're going to get. We are, and I would say that we're in a very different space than we would have been many years ago. The National Claims Information Database, which the central bank produced, I think is a game changer in terms of us having moved from a space where we had translucent, if not opaque, data in terms of the sector to a sector that now you can have a much more transparency, but we're also not talking about anecdotal information. We know what's being done in each settlement channel. That wasn't there a few years before. And it's funny how quickly we adapt to things and you kind of accept that it's there, but it is a huge difference from where we were before. Obviously, we've a huge amount of other reforms coming from the Action Plan for Insurance Reform and the previous programme for government, and indeed this programme for government are committing again to a renewed Action Plan for Insurance Reform. That's important in terms of keeping a focus on insurance reform. I don't think it's ever going to be an area where we just stand still. We're always going to have to keep moving on it. But the guidelines, I think many of you will have seen, have been an absolute hugely systemic change in terms of how we assess claims. In Ireland, it's a very different awards framework. And again, while there's a lot of focus on values of claims within this, the big thing about the guidelines is that they were about consistency and certainty in Ireland, and that we were all meant to be working off the same framework, and we're meant to give a reason where we're departing from the guidelines. Hugely important that we had last year, 3 years after the guidelines came in, a Supreme Court case, bringing kind of that consistency and certainty to that by then saying, yes, the Supreme Court case are saying these are constitutional, they are here to stay. And for us, because we were a party to that Supreme Court case, and as it travelled through the courts up that, to say that the Injuries Resolution Board had applied those correctly and had been doing a good job in doing so. So important in terms of people building trust in terms of the service that we're providing. But we've also had duty of care legislation, and for the Injuries Resolution Board, a new piece of legislation saying, how can we do more to resolve claims? And I'm going to come back to that later on. But one thing, and if anybody has heard me speak about this before, I will keep talking about it. I can't help but do it. Everybody, when we talk about the guidelines, all they do is focus a lot of the time on what's the average award, or Lauren will talk to the median award, and she will cover all of that this afternoon. But for me, the biggest change that you're going to look at, and the most significant change that's happened in the last 5 or 6 years, is the change in terms of the number of claims that are coming through the system. And the Injuries Resolution Board, for any of you who don't know what we did, and by the way, our former name was PIAB. So if you're wondering who the Injuries Resolution Board, yeah, we're PIAB. And we take all claims in Ireland have to come through us unless they are resolved early and directly with an insurer or a respondent in Ireland. You can't get into the litigation system without coming through us. What that means is, even though not all claims are directly settled with us, we have visibility on all claims essentially that happen in Ireland. And through that, we can see there's been a huge change in terms of the volume of claims that have come through over the last number of years. And I mentioned COVID earlier, and so there's an assumption that that big drop off that you see there on that slide from 31,000 to just over 20,000 in 2021, we'd start to see that coming back up. But that's not what we've seen. And again, you're here, we've just put together our 2024 data, and we haven't got it all done there. So I'll say they're in draft for the moment. But what you'll see in terms of last year, we had 20,837 claims come to us. It's only a 1% increase on the year before. The year before that, we had a 10% increase, but from a low of 18,000. And what we're not seeing, and we're not predicting, by the way, is any huge climb back up in claim numbers. I looked at January's figures there, we're down 8% on last year. So there's not some big numbers that are coming back up here. And what does that mean in terms of overall terms is the biggest change to happen is in terms of the monetary value of awards is the overall amount of awards in Ireland has gone down significantly, not just because awards have been recalibrated in terms of guideline values, but because we're not getting those awards. So when we look at the impacts of the guidelines and of reforms, we can't just look at the impact in terms of what does a median or average award look like. We have to look at the fact that the awards aren't being made anymore. And it's one of the things that I suppose I get frustrated at sometimes when we're having dialogues around these things. Turning, I suppose, to ourselves, and often, and rightly, by the way, there's dialogue about, well, there's still far too much cases going into the litigation system, and how many cases are actually being resolved by the Injuries Resolution Board. One of the better impacts that we've seen over the last number of years is that we had a consent rate of 55% for years, 55%, and the consent rate being the respondents and the insurers coming to us and saying, yes, we'd like you to assess that claim. So what claimant can come into us and they have to come through us. The respondent on the other side gets to say, yeah, I think it would be worthwhile for the Injuries Resolution Board to assess that claim, or no, we think it would be better to travel through the litigation system, and I want to challenge liability, for instance, through the court system. And that stood static for years and years at 55%. We hit in 2023 71%. That's the highest number in the history of the Injuries Resolution Board, or PI, of the 20 years that we've been in existence, that it's ever been. And we managed to maintain that last year. What that means, even though overall volumes are down by 35%, in terms of what we're dealing with, it's only down by 16% in net terms. So the amount of cases that we're managing to keep within the system, it is much bigger. Why is that important? It's really important because when I look at my 2023 figures and we go, well, how much did it cost for every case to go to litigation? Using those NCID figures that I just talked about, we saved about 75 million just from the cases that were consented to and accepted then, where both parties accepted awards within our system. Now in 2023, our acceptance rate was 48%, so it was still below where we were pre-guidelines. Last year, I suppose, as that Supreme Court case came through and everything, we hit 51%, which is really where we were pre-guidelines. So what that means is that 75 million figure, which we haven't calculated in terms of this year, in terms of 2024 yet, will only grow in terms of the amount of money that we can save in terms of the cases not going into the litigation system. So I suppose the second message, apart from volume, that I want people to think about in terms of when we look at reforms is it's about the systemic cost. Again, it's not about the average award or the median award. They're really important, but the systemic cost is how, if we can stop cases moving into the litigation system, there's actually much more value in terms of savings within that. And then if you start taking into a bigger CBA kind of analysis of that in terms of the time that claim handlers are spending it, or the time that businesses are left with higher insurance costs while claims are going on, that value is much more significant than just that 75 million euro figure. The third area that I wanted to touch on was just our new mediation service. So if you take the potential impact that we could have if our consent rate was higher again, if we had that acceptance rate higher again, what we can do is much, much more. And because of that, we worked with government to bring in new legislation, which was all about enhancing and reforming the services that we provide in the Injuries Resolution Board. And it's why our name has actually changed, to move us from maybe being a singular entity that's all just about personal injuries assessment board, is what we were before, to the Injuries Resolution Board, so that we would take a broader focus on how do we resolve claims in Ireland. There was three main parts to that. One was bringing in more anti-fraud measures, having a more robust application system. I won't go into the details of that. The second is us having a much more utilize our data in a much more meaningful way and have a research function, and Lauren will talk to that. But the third area was this mediation service. Why is that important? Because we move from a black and white world where our assessment service has been hugely valuable, but it is all based on paper and a medical report coming in and us dealing with independent medicals. That meant if there was queries on either side about the level of injuries, previous accidents, liability, none of that could be discussed within the forms that we had available to us. Mediation, which we've now just in December launched for motor as well, now is a game changer for us in terms of bringing about a forum where people can discuss those things and they can look at partial liability or broader things. While it's still early days, we do know that the time that it's taking to resolve those claims is even better again. So rather than the 9-month time frame, which would be in the assessment channel, you're looking at 4 to 5 months to resolve a claim within the mediation channel. It's through an independent shuttle-based type of mediation service through one of our independent mediators. And so far, we're getting really good buy-in from our claimants. And a lot of people would have raised their eyebrows and said, oh, who's going to buy into this from a claimant side? But we are getting good buy-in. It's varied between 35 and 40%, which for the first year of operation, we're very, very happy with. We're starting to see more buy-in from our insurers. That has been a little bit slower, it's fair to say. And I think that's probably because we're doing the toe in the water, seeing how successful it is. And as that happens for each of the respondents and insurance companies that we work with, it will bring more to light. But it is an important part of the overall changed environment, and I think has the potential to increase that number in terms of resolved cases within our channel. Just the final thing that I wanted to talk about before going over to Lauren is just the draft personal injury guidelines that have been published by the Judicial Council, and they were published just before Christmas there. And I know many of you might be aware of them, but I think it'd be remiss not to just highlight kind of what's coming down the road. So what the draft guidelines do is they apply a 16.7% increase across all categories within the guidelines. And that link has been that rise has been linked to a rise in inflation generally, and what the council have done is base that on the harmonised consumer price index. I suppose it's important to say that there's been no changes to categories or brackets beyond kind of this. So it's a very kind of blanket increase that's gone across the board. And I suppose where we might have seen nuances where there might be a gap in certain areas within the brackets where, for instance, at the moment we have categories of injuries, we have recovery times, and then there's brackets between some of those. And sometimes there might be quite a gap between one area and another. Those areas haven't been addressed, or specific issues around particular injuries. It has just been across the board, kind of fairly blanket approach in terms of the increase that's been applied. The other thing that's probably not been noticed by so many, and it's again because we're so fixated on values, is the fact that there's a new methodology for the calculation of injuries within those draft guidelines. For us, that has many implications, and I'll talk to the implications a little bit more, but it moves us away from the original guidelines, which said that we valued most significant injury and did an uplift thereafter for other injuries, to one where you now look at in the case of multiple injuries, which by the way is 90% or more of the injuries that we would see. It's very few cases that come in with a single injury. To looking at each injury separately, giving them all of them evaluation, and then applying a discount on that, rather than the other way around. That has implications that I will talk to just in a minute. Just in terms of implementing the draft guidelines and how do we get to approved guidelines and what does that mean? So it's the committee of the Judicial Council that are responsible for drafting the guidelines. They then go to the board. In this case, the board made a slight amendment to the guidelines to take account of changes in CPI that happened between the committee and the timeline to which the board had looked at it. It then goes to the council. That happened just last week for anybody who was following that, and the council approved them in principle, so to speak. And then under the new legislation that came in recently, they go to the Minister for Justice for approval, who places them before the Oireachtas. So we are now at the point where they have been submitted or are in the process of being submitted for the Minister for Justice. They then need to be placed before the Oireachtas, and then they go back to the council for final adoption. So that is the process. That they are not in place yet. We don't have a timeline of when they will be in place by. My guesstimate, and that's all that it is that could be by the Q1. But again, we can talk to that a little bit later. Just for us, and again, we can spend more time on this later on, but the impacts going forward and maybe some of the things to think about around this. For us, we are the body that have to implement this straight away. So if you think about when you go to court, it takes maybe 2 or 3 years for most cases to get into the courts. And that's if you're lucky. Sometimes it's actually 5 years from the date of accident. And that means we have to apply these new methodologies straight away. So we have operational issues to consider in terms of operationalize these into systems and so on. But apart from that, you're going to see Lauren present all of this data that I just talked about. And with the new methodology, we have to think about the before and after in terms of comparisons. How are we going to compare what went before, because there's a new way of applying guidelines, to what will go after? And that's something that we're trying to figure out at the moment to make sure that we can keep looking at the impacts of changes as they go forward. We also have to consider, what does it mean to depart from the guidelines? Under the previous framework, where that methodology was the most significant and an uplift, what you had there was a system whereby you really could see in a more transparent way how somebody had applied the guidelines, because they're very clear, well, I've picked this injury. So we really will need to see how the judges and ourselves are writing down our assessments so that we can understand how the guidelines are being applied. So that's a question mark in terms of how will that be seen. One of the areas maybe that I think probably we could learn from the last guidelines is that delay or lag in terms of cases going into the courts causes in itself uncertainty. You'll hear insurers, I presume, today in our actuaries tell us that, well, they've no certainty in terms of that view of what the court's interpretation is going to be. And so it would be very, very helpful if we could have some cases fast-tracked into the court system so that we got early interpretations, because we won't have any interpretations from the courts, and all you're going to have is us applying our interpretation of the guidelines, which we will do with help of senior counsel and so on. But again, just to get that consistency, I think it's an important learning from before. And going back to the fact that consistency and certainty is the objective of what we're trying to achieve through the guidelines, we do need to keep an eye on that overall. And from that, to me, there's an ask of all of us within that. We often think about the courts, and I've just mentioned them there, and they are very important, but only between 1% and 3% of cases go into the courts and are ruled on. So in between that period, we're the guardians of what the guidelines actually mean. And it's something for us all to maybe consider. So how do we, between us all, have consistency and certainty? Certainly us producing data, I think, will help with that, but it is a question mark there for us within the intervening period. And the last thing, just before I hand over to Lauren, is just maybe to kind of leave as something for people to think about, is this is the first time we've seen CPI applied so in such a direct way to what would be general damages, special damages, the damages for loss of earnings and all of those things obviously always has an inflationary element applied to it. So what does that mean in the medium to long term? The Judicial Council by law have to review the guidelines every 3 years. At this point, that means that they could be reviewed again before we've even seen many cases go through the legal system, go through the court system. So how are we going to, and what can we expect of what comes after that? And I think that's a broader policy question that we're just going to have to look at and think too. So with that, I'm going to hand you over to Lauren, who's going to give you the whistle-stop tour in terms of what the data is actually telling us.
Thanks very much, Rosalind. I'll just throw my screen on now. And hopefully you can all see that there. So I'm just going to bring you through some of the latest trends in personal injury claims. It will include data that we haven't published yet, so from our upcoming award values report for 2024. We're also going to take a closer look at motor liability claims and awards over a 6-year period, and some key findings from our public liability report, which you may have seen online, that was released about 3 weeks ago. So just to, I suppose, some context research at the Injuries Resolution Board, as Rosalind said, I'm the head of research and policy, and research is a new function to the board. So there was legislation enacted in 2023, which enhanced the functions and the remit of the Injuries Resolution Board. But one key area of focus was to establish a formal research function. And really the new research function that allows us to identify new and emerging trends in the personal injury landscape. This is important because we are the central body that collects data relating to over 20,000 accidents each year. And each of those has a claim application and setting out the nature and the cause of the accident, and it may have multiple medical reports. We also have data that's generated through our assessment and our mediation services. So we can really provide, I suppose, a complete picture on the true cost of accidents, both in terms of the economic cost, but also the personal cost on the person that's injured in the accident. One of our reports that you may know well is our award values report. So this was first launched after the guidelines were introduced in 2021, and it aimed to, I suppose, monitor trends in award values over time. It's now in its 7th iteration, and we've really focused on trying to improve the methodology of the reports and try and drill down more and more into the different injury trends that are fueling any changes in award values. Just to give an overview of trends in median award values, so we've moved, while we still talk about the average award values and show those statistics in our reports, we now focus on median award values because the distribution of our awards has changed. We're now assessing more high value cases, so it's really a more robust metric to monitor changes in award values over time. When the guidelines were first implemented in the first 9 months of operation, median award values between April to December 2021 decreased by 46% in comparison to the median award value in 2020. In subsequent periods, award values have increased. So they were 44% lower in 2022, 37% lower in 2023. And in 2024, the median award value was 13,000, which is a 30% decrease on the median award value of 18,450 in 2020. And I'm going to just bring you through some of the key factors that are influencing that increase in award values. So the first and perhaps most important factor is that the Injuries Resolution Board is assessing more complex injury cases. And the reason for this was in 2023, we had new legislation enacted. And the first part of that legislation, it allowed us to retain and assess cases of a wholly psychological nature for the first time. So while we always assess cases that maybe had a psychiatric element as a secondary injury, we were able to retain cases that were primary psychological in their nature. The second part of that legislation, it allowed us to retain cases, more complex injury cases, until a stable prognosis became available. So we're now retaining those cases within our system until a stable prognosis is available. And then the consequences of these legislative changes and the introduction of the guidelines is that between April to December 2021, neck and back injuries accounted for a majority of all the awards we made, so 53%. And across subsequent periods, this percentage has steadily decreased to 46% of awards in 2024. At the same time, this has coincided with an increase in the number of awards that we've made for psychiatric injuries. So psychiatric damage injuries accounted for 5% of awards in 2021, increased to 8% in 2022, 12% in 2023, and now 13% in 2024. We suggest here that this trend appears to have stabilised, and that's because in previous periods, when we looked at the first half and the second half of the year, we could actually see an increase in psychiatric damage awards just across a 6-monthly basis, where in 2024, this remained stable in the first half and the second half of the year. So we think we may have reached a new normal in terms of the type of injuries that we've assessed. While we can see changes in the type of injuries that we're assessing, we can also see changes in the severity of injuries that are presenting for assessment. So when we look at the most common injury types, they're your orthopedic injuries and your psychiatric damage injuries that can be classified in the guidelines neatly into minor, moderate, or severe and serious injuries. What we can see is that in 2021, just 15% of awards were for the moderate to serious severity injuries. And now this has increased to 25% of awards made in 2024. You can see, I suppose, from the data, and I hope from the data here, how useful it's been to have the most significant and dominant injury tracked as per the guidelines over time, so that we can identify key changes in the type and severity of injuries. So we've been tracking this for 4 years now, close to 30,000 assessments made under the guidelines. But if new methodology is introduced and we no longer see a most significant or dominant injury, it's essentially going to be a reset in terms of the data that we've collected so far, and running any comparative analysis is not going to be as easy, or we're not going to have the same level of confidence as what we had before with this level of data. Just some key trends in terms of an upcoming motor liability claims and awards report, and it's going to look at key trends between 2019 and 2024, and these are just some of the headline findings. So on the left, you can see annual motor liability claim volumes. So over this 6-year period, we received over 70,000 motor liability claims. And we can see that in 2024, motor liability claims increased by 4% in comparison to 2023. However, motor liability claims, they still remain 30% lower than what they were in 2019. Just some important considerations when we're interpreting these changes, that motor liability claims, so most claims that are submitted this year actually relate to accidents that occurred last year. So there's around a 0.9 years gap between the accident date and the claim submission date. And then if we look at some other trends that might be influenced, like one of the most common considerations that is brought up is around the impact of COVID-19 on traffic volume. So where are we now in comparison to pre-COVID? We can see that from data from Transport Infrastructure Ireland. They show that in 2024, by October, we were actually back to traffic levels for cars that are higher than what they were prior to the COVID-19 pandemic, and 36% higher than what they were in 2020. And we can see a similar increase for HGV traffic volumes, which were 5% higher than what they were pre-COVID-19 in 2019. Another important metric is serious and fatal incidents that occur on a road. So in our last annual report in 2023, we would have highlighted a 20% increase in the number of fatal motor claim applications that were submitted to the board. We can see from the data from Garda Síochána, it shows that actually the number of fatalities last year were similar but slightly lower than what they were in 2023, and our provisional data suggests that the number of fatal motor claims is actually going to stay the same too in 2024. So while we know that overall motor liability claim volumes have decreased by 30%, we can see that when we look at changes in claim volumes between 2019 and 2024, that actually the decrease hasn't been uniformly distributed across all of our road user groups. So we can see the highest decrease in volumes for motorcycle users, and then this is followed by car passengers and car drivers. Two exceptions to this are pedestrians. So we can see claim volumes for pedestrians have almost returned to what they were in 2019. They're just 8% lower in 2024, and HGV, van or truck users, so that's drivers and passengers, has increased by 16%. But this, I suppose, it's a small sample within this road user group, so just to note that. Pedal cyclists, well, we note here that they've decreased by 32%. This may be an overestimation because earlier this year we added e-scooter or e-bike user as a code to track trends in road user claims. So prior to this code being in existence, many of these claims may have been put under cyclists in our data. So just something to be conscious of when we're interpreting those statistics. In terms of trends in motor liability awards, so we've tracked injury severity, so for minor, moderate or severe and serious injuries based on road user group. And what we can see is maybe what you would expect here, that more vulnerable road user groups such as pedestrians, motorcycle users and cyclists, they're more likely to sustain injuries of a moderate or severe and serious severity level. And this corresponds very closely with the average award value that we see for each of these road user groups. The lowest average award value in 2024 was seen for car passengers, and they have 84% have minor injuries, followed by car drivers and bus users as well. So the groups that tend to have more minor severity injury levels there. In terms of overall trends in motor liability awards, between 2019 and 2024, the board made assessments of compensation to the value of over 700 million. The total value of awards made in 2024 was 41% lower than what it was in 2019. The median value of motor liability awards in 2024 was 12,540, and this compares to 22,000 in 2020, so it's a 30% decrease. In terms of trends that we're seeing for motor liability awards, it actually mirrors very closely the overall trends that we're seeing. So we've seen a significant reduction in the number or proportion of awards made for neck and back injuries, reducing from 68% in 2021 to 58% in 2024. And then at the same time, again, we've seen this increase in awards made for psychiatric damage injuries. So this accounted for 6% of awards made in 2021, and it now accounts for 16% of motor liability awards made in 2024. Just to give a very brief overview of some of the key trends we've seen in our public liability claims and awards report, which was launched in January this year. In a 6-year period, we received over 34,000 public liability claim applications. What we can see when we look at it on an annual basis is that public liability claims in 2024, they actually remain unchanged on 2023. So there's a less than 1% difference between those 2 years. So that's really given us, I suppose, suggesting some of the first evidence that it cannot be COVID-19 alone that's driving this ongoing reduction in claim volumes, because if it was just that as the sole factor, we would have expected to see even a slight increase in claim volumes this year for public liability. When we look at the volume of claims, so this is for 2023 versus 2019, across different sectors, we can see that the largest increase was for cafe, hotels and restaurants, decreasing by 52%, followed by shops and stores, a 44% reduction, and sports and athletic areas, which decreased by 38%. The one exception to this decrease was claims in residential institutions. And what we mean by that, so that would encompass nursing homes, long-term care settings, prisons, detention centres. The claims within that sector increased by 22%. So when we went into the files to understand what was actually driving that increase, we could see that it was a group of claims, fatal claim applications made for fatal incidents in nursing homes during the COVID-19 pandemic. In terms of some statistics on public liability awards, you can see that over a 5-year period, we made assessments of compensation to the value of 130 million. In 2023, the total value of public liability awards was 37% lower than what it was in 2019. And in 2024, it was 43% lower than 2019. We can see that public liability awards, the median value has reduced by 40%, but the average value has reduced by 22%. And that's because as we're assessing more complex injury cases and high value cases, the average award value is becoming increasingly skewed. So that's why we're reporting on the median value here. What's interesting about public liability claims is that it has the lowest consent rate. So the lowest proportion of respondents opting into our assessment service. So that's at 54% in 2023, and that compares to 80% for motor liability claims. So just to put that into context there, it really shows the potential for a new mediation service. What we hear is that contributory negligence is often the reason why maybe some respondents or insurers won't opt into our assessment service. But where we are given a chance to assess, we can see that public liability assessments have the highest acceptance rate. So in 2023, this was at 57% compared to an overall acceptance rate of 48% that year. And then finally, just I suppose as the research function moves forward, we want to try and use our data more and more to answer questions maybe about some sectors that we know a lot less about. So for example, the childcare sector is a sector that historically has reported issues in securing affordable insurance premiums. So we want to try and quantify the risk for this sector for public liability claims. And what we found was that over a 5-year period, we could identify just 256 person injury claims that were taken against childcare settings. And this is in context to over 170,000 children that are enrolled in such services each year. So while they're not free from risk, what our data shows is that this setting is actually generally safe in the context of how many people are utilising these services. So while we want to release more and more data to try and quantify risk and for existing insurers or perhaps new entrants to the market, we're also trying to use our data, so like the table on the right here, for childcare operators to actually understand, okay, what are the most common causes of accidents within our sector. We go into a very detailed analysis highlighting exactly what are the most common causes of accidents for children within these settings. So thanks very much.
Thanks, Lauren and Rosalind, for that very informative presentation. It was great to see that you included draft 2024 information in there as well. It really gives us an up-to-date view of the market trends. So, we're not waiting a few months to see them. So that's great. And thanks. And look, I can see there are a number of questions from attendees in relation to your presentation. I might just get the ball rolling. First of all, Lauren, if I might ask you, just in the presentation and in your PL accident report as well, which I read in January, it was another accident report from the IRB, there's been a reduction in frequency, reduction in, I suppose, number of claims of about 35 to 40% across motor, EL and PL between 2019 and 2024. I suppose I'm just trying to understand, maybe, do we know the reasons behind this dramatic reduction?